Hello and welcome, everyone. I'm delighted to greet you here for the World Bank's Virtual Law, Justice and Development Week 2020. My name is Mike Strauss, and I'm the General Counsel of the European Bank for Reconstruction and Development. I'll be moderating the first part of our discussion today about online courts and what they portend for the management of commercial disputes. We will also cover how we can rethink court proceedings to make courts more accessible to businesses, focusing especially on small claims and SMEs. Although online courts are not new and have been in existence in some jurisdictions for more than a decade, COVID-19 has pushed this idea into the mainstream. As some have said in this crisis, in the digitalization space, the pandemic has made possible in days what many have tried to do in vain for years. That makes this a very timely discussion, and indeed, the pandemic has heightened the challenges that businesses were already facing, including efforts to enforce contracts in the courts. As you may know, the EBRD is a major investor in economies across 3 continents, helping businesses grow and flourish through financial investments, business services, and most relevant for today's discussion, through our involvement in high-level policy reform. With this in mind, today's discussion also provides an opportunity to explore how the EBRD, the World Bank, and other IFIs should continue to make a significant impact on the legal environment. But before turning to introduce our distinguished panelists, let me first ask our generous host, the General Counsel of the World Bank Group, Sandy Okoro, to welcome you to the discussion and give us a sense of the World Bank's thoughts about online courts. Dear Sandy, over to you.
Thank you very much indeed, Michael, and good morning, afternoon to all of you, depending on where you are in the world right now. It's great to see you. And this is the first time we have done LJD Week fully virtually. So we really are in a new world. I'm thrilled to be with you today to listen to this discussion. As we think about the future in the so-called post-pandemic world, I know we are all itching for some practical ideas on how to make changes and move forward. And I'm sure we're also, on a human level, all itching to see and hug our family and friends as well. And I would like to remind everyone of the problem at hand. The world continues to suffer a tremendous justice gap. And this existed before COVID. And we have to ensure it doesn't get worse post-COVID. So let me just give you some interesting stats. I know everybody likes stats. I like stats, and they tend to put things in perspective. So we know that roughly 1.5 billion people have justice problems they cannot resolve. That's 1.5 billion people. Women enjoy only 3/4 of the legal protections enjoyed by men. And COVID-19 exposed weaknesses in justice systems while likely inundating court systems with new cases. That's without doubt. And for example, we're seeing steep rises in reported cases of gender-based violence and also in the severity of that gender-based violence, which is extremely worrying and puts women in a very, very vulnerable position. And of course, recent social unrest around racism has exposed the role of justice systems in perpetuating structural inequality. The justice sector is also slowly being forced to reconcile with the concept of people-centered justice. And what does this mean? Well, for courts, it means that services need to be tailored to the needs and the resources of the parties rather than to needs of the lawyers and the court staff. The COVID pandemic has forced courts to quickly adapt to use remote and virtual technology. It has also forced court users to adjust online services as a substitute for their day in court. And as Michael said in his opening, we are doing things we never thought we would see ourselves do. And all those things we thought we couldn't do, we are now doing. We really are in a new world. And there are several valuable lessons here. Successful court adaptations should be made permanent and scaled up, not just for Christmas, but for life, as they say. We should also pilot innovations and evaluate results. Now is the time to bust myths around online courts using data and evaluation. The bank is rallying our member states and partners around the idea of building back better. So again, I will just repeat, we are doing what we thought we could not do, and we need to keep doing it. But we do need to be sure we are doing more than just virtualizing court procedures that leave citizens confused, perpetuate unjust practices, and otherwise limit access to justice. And access to justice really is an issue for many. As always, we need to keep an eye on ensuring that vulnerable groups are not left behind, and see how online courts help close those justice gaps we have already identified. The effect of COVID-19 on business and commerce, of course, cannot be overstated. We are all very, very aware of that in our everyday lives. It has altered project timeframes, fractured global supply chains, interrupted the international labour market, and many contractual obligations remain unfilled. So the courts are going to be very busy very soon. Businesses have had to reassess their finances, the markets in which they operate, their customers, and their ways of working. Indeed, resolving these commercial disputes is an important part of the economic recovery process. Small and medium enterprises may be particularly at risk. Issues like breach contract, insurance disputes, consumer complaints, and bankruptcy are likely to surge along with the pandemic, and the courts will need to respond respectively. So it's not just a health crisis, it could be a justice crisis as well. Although the pandemic is what pushed many commercial courts online, we now have the opportunity to make online courts a reality in the long time, and I would say at long last. It is imperative that we meet this challenge in a way that helps bridge the justice gap we talk about, not make it wider. The Legal Vice Presidency recognises the critical importance of access to justice in addressing poverty and inequality, and so that we can boost shared prosperity. Technology has a very important role in promoting such access. As part of this commitment, we've recently launched a collaboration with the Government of Korea, a 3-year programme on access to justice and technology, which we are very proud of indeed. This programme aims to support the use of technology to better serve citizens and close justice gaps, including support for online dispute resolution and e-services. We are proudly supported in this endeavour by a newly established Access to Justice and Technology Task Force team. Very proud to say that. Today's discussion will hopefully provide us with some guidance and insight into how this agenda may move forward. We have some wonderful panelists. I know you will enjoy hearing from them. And we are really delighted that they are here with us today. They are highly respected experts in their field. I know you will benefit from hearing their perspective and their opinions on this issue. So I will wrap up by saying I look forward to the discussion. I know you will enjoy it. You will learn many things from this session. And I'm now going to hand back to Mike so that we can start this session. Mike, over to you. The floor is yours.
Sandy, so much. Thank you so much. And first of all, my apologies if you hear a growling creature in the background. It's just my dog. So he enjoyed hearing what you said as well. And in particular, I thought what you mentioned about the surge that we're actually going to see in commercial disputes coming forward because of COVID actually underlines that this is not actually just about making a change or virtualizing courts as they exist, but we're actually going to see a backlog in the deficits in access to justice. And that's something we have to pay very close attention to, and I think several of our speakers will probably comment on. So let me actually now introduce our speakers, our esteemed panelists for today's discussion. I'll start with Professor Richard Suskind, who has been the technology advisor to the Lord Chief Justice of England and Wales since 1998 and is the driving force behind the digital reform of the judiciary in the UK, as well as one of the leading voices for the transformation of courts across the world. Richard is the most cited author on the future of legal services, and his latest book, Online Courts and the Future of Justice, is a case study in the digital transformation of a vital public service. Judge Olena Kibienko is the judge of the Grand Chamber of the Supreme Court of Ukraine and is actively involved in the ongoing digital court reform in Ukraine. Olena is a prolific author on e-justice solutions. She holds a PhD in law and was a managing partner at a leading law firm in Ukraine before she became a judge. And finally, last but not least, Klaus Decker is a senior public sector specialist at the World Bank, where he is currently the chair of the Justice Community of Practice. He's a French and German trained lawyer with almost 20 years of experience at the World Bank in promoting justice sector reform initiatives worldwide. Thank you, all three of you, for joining us, and I'm truly looking forward to our discussion today. Now, just before I hand over to Richard to start us off with a discussion about why online courts may be such a good idea, I'd like to encourage the audience to join the conversation by posting your questions or comments in the Q&A chat section. We'll have about 10 to 15 minutes at the end to discuss these questions. And finally, one housekeeping note. Part of the way through this seminar, I'll have to jump over to join Sandy for the IFI General Counsel's Roundtable, at which point my colleague, Veronica Bradatsano, will take over as moderator. Richard, over to you.
Many thanks, Michael, and good day to everyone who's watching. It's a great pleasure to be with you. I wanted to ask and answer 5 questions today. The first is, what problems do our current courts, with particular reference to commercial courts, face? Secondly, what mindset should we have in thinking about the future? Thirdly, what technological options are open to us as we try to plot and plan our way through the 20s? Fourthly, and penultimately, what's the potential of what I call front ends to traditional court systems? And finally, what role might AI play? Now, necessarily in 15 minutes, I'll be skimming, but I hope to give you a flavor of the broad territory here. So starting off with what problems our courts face, it seems to me that our current system globally, a system based on physical hearings, is currently not coping for 3 reasons. The first, self-evidently, and so sadly, is that many courts are closed because of the virus. Secondly, because again of the virus, large backlogs are building up across many jurisdictions. And thirdly, and Sandy talked about this, we have, frankly, the traditional access to justice problem. Now, although we're talking today about commercial disputes, I can't let it go unnoticed that figures of the OECD suggest that only 46% of people in our world live under the protection of the law. And that, I think, should bring collective shame to all of us who are involved with justice and law. We just have to do a better job. And so while I want to focus on commercial disputes, we should never forget this justice gap to which Sandy refers. But the third problem we can define in commercial terms the traditional problem of proportionality. And that is simply this, that even in the so-called most advanced court systems in our world, most commercial disputes cost too much, take too long, the process is unintelligible, it's much too combative, and increasingly it's out of step in a digital society. So I'll say that again, even our most advanced court systems, most commercial disputes cost too much, they take too long, the process is unintelligible, it's too combative, and out of step in a digital society. Now, this is something, again, we as lawyers should be distressed about. We should be moving towards a system that actually overcomes these various difficulties. And I'm referring here to disputes not just for major multinationals that have general counsel and in-house legal teams, but perhaps more importantly, for small businesses for whom the law is increasingly out of touch and for whom the law is it's inaccessible. So what mindset should we have if we want to think radically about improving our service? Well, the question I ask in this context is this. Is court a service or a place? Do we really need to assemble physically in some actual location to resolve all our legal differences? Or might, in a digital society, might there be different ways of us resolving and avoiding and containing legal problems? So that's the challenge, I think, we set ourselves to answer that question. For those of you who have heard me before and seen me before, you'll know my signature slide. I usually put up a slide of a power drill and tell the story of Black & Decker, one of the world's leading manufacturers of power drills, who apparently when they recruit new executives, take them off on a course, put up the very slide I show and say to the assembled new executives, this is what we sell, isn't it? And the new executives all look rather perplexed by this. They say, of course, that's what we sell. We're Black & Decker. We're the leading manufacturers of power tools. And the trainers, with some satisfaction, put up a new slide. And it's a picture of a hole neatly drilled in a piece of wood. And they say, that's actually what our customers want. It's not the power drill they want, it's the hole, it's the end product, it's the outcome. And it's your job as new executives to find ever more competitive, imaginative, creative ways of giving our customers what they want. Now, isn't that the way we should be thinking about lawyers, as lawyers and as judges, about the future of the court system? Almost all discussions of the future of courts tend to be about, if I can use the metaphor, putting in place a lighter, quicker, cheaper power drill. We should be taking a step back and ask, what's the fundamental value we bring to those we help? And might that value be delivered in new ways. That's our challenge. And also a mindset issue, we've got to think beyond automation to transformation. And Sandy hinted at this again in her introduction, but automation for me is about using technology, grafting it on to existing processes to make them a bit quicker, cheaper, better. I sometimes call this mess for less. Well, you're still going to mess in the process. You're adding technology on it somehow to make it a little less messy. But the real power of technology is not to perpetuate or render more efficient our old working practices. It's to transform. It's to allow us in technology and law to deliver legal and court services in new ways that improve access. It's to use the power of technology to transform how it is that we work. So what are the technical options here? Well, isn't it fascinating, again, as both Sandy and Michael noted, that over the last few months, we've seen an acceleration of a whole variety of technologies. I also, and this is for a longer talk, think there's been a deceleration of other technologies, that perhaps for question time. But if you look at remote courts worldwide, which is a website I was involved with setting up, www.remotecourts.org, you'll see what we've done is gather together the experience of news from over 50 jurisdictions, seeing how it is that jurisdictions have adapted and moved from physical courts to a variety of remote options. And I think there's a terminological issue here. I wrote a book on online courts, but I have a very specific definition in mind. Other people equate video hearings with online courts. Now, the term we use, remote courts, is a generic term which covers three options: audio hearings, video hearings, or paper hearings. The audio hearing is a hearing, as one might expect, by some kind of telephone conference call. The video hearing is, using technologies much like the technologies we're using today, the conduct of a hearing using video conferencing. And the third, the paper hearing, actually there's no hearing at all. There's no oral evidence. It's when evidence and arguments are submitted in written form, almost like an exchange of email with the judges, and there's an online discussion, but it's an asynchronous process. It's not a live process where everyone needs to be in attendance at the same time. It's a way of exchanging arguments and evidence, and a way of the judge delivering his or her decision without physically assembling either in a courtroom or in some kind of video hearing. Now, there are the three options. There are some variations that sometimes audio and video hearings are partial, where there's a physical hearing and some people are participating by audio or video, and sometimes they're full audio or video hearings where everyone is participating in the same way. Now, what conclusions can we draw over the last 7 months? Well, I think what we've seen, the default preferred remote court or remote hearing has been the video hearing. And I think, echoing again earlier remarks, this has worked out far better than most people could have expected, even say in January. The early evidence, good empirical evidence, serious research in various jurisdictions suggests that video hearings work satisfactorily, often way better than that, and often much better than people had feared. But it's early days yet, and we're still feeling our way, and we have to gather data about what's working well and what's not working so well. But I mentioned my book, Online Courts and the Future of Justice, and people often kindly say I was prescient, but of course I had no idea a pandemic was coming along. But more than that, I wasn't really talking about video hearings. I speak about it quite a bit, but I'm more interested in, according to my definition, a particular kind of online court, and there's two elements to it. The first is online judging, and that's the same as what I've just mentioned as a paper hearing. The idea of online judging is it's a human judge receives arguments and evidence in electronic form, engages in some type of online exchange with clients, with the court users, and then responds with a decision in electronic form. Now that looks way less radical than it did 6 months ago, but it's still been only minimally adopted as an alternative during the COVID crisis. But the second element of my online court is, I think, far more radical, and to some extent doesn't challenge, but it complements what Sandy was saying about the justice gap. Many people talk about the justice gap meaning in access to courts, and of course that's terribly important. But I think there's a bigger gap, and I call it the justice gulf, and that's the gulf between knowing your entitlements and being able to enforce your entitlements. So many people have said over the years, the answer here is to have online websites that help people understand their entitlements. That's a bit like being told your medical condition without there being any drug available or any surgery available to sort it out. There's a gap, a huge gulf between understanding and enforcing your entitlements. And I believe, and this is radical, but I believe in the future, it's not enough for the state just to provide a dispute resolution function, just to provide binding authoritative decisions, because most people can't afford the legal help, the legal guidance, legal counsel to take them before the court. And so we need online tools, and this is a secondary function for me for the state and the courts, which help people understand their rights and duties, their entitlements, which help people identify the legal options and remedies available to them, which help them organize their evidence, which help them structure and organize their arguments, which provide online tools to help negotiation or some kind of non-judicial settlement, not as a private sector alternative, but baked into the court system. So that's my vision of tomorrow's court system, that particularly for low-value commercial disputes, where it's disproportionate to instruct lawyers and attend in person and wait months and enter into major combat, why not have online submission of arguments, online judging, and why not have a whole set of tools so that small and medium-sized businesses can understand and pursue their own cases? So what role might front ends play? I mentioned this notion of the front end. Well, to cope with the backlogs and to increase access, it seems to me we need to find new ways of resolving commercial disputes. Our court systems as currently constituted simply won't have the capacity over the next few years to resolve all the commercial disputes that are in play, and not to mention those that have arisen during the COVID period. Now, rather than encouraging parties to jump directly into formal court processes, surely we should be able to offer upfront an alternative suite of affordable, usable, and intelligible online facilities. Now, the spirit here, of course, is the same as traditional ADR, but it's online. One of the problems with ADR, I perceive, is that it still required people to turn up at physical locations, and it's still usually a guy like me, a white guy in a suit in his 50s, who's doing the mediation or who's doing the facilitation. An online resolution service would be entirely different, far more convenient, far less about resolution, more about containment and avoidance. We have to somehow de-escalate many commercial disputes, whereas I'm afraid the court system, and increasingly say arbitration as well, invoking lawyers tends to escalate. But in the end, we want surely a fence at the top of the cliff rather than an ambulance at the bottom. No one wants a good dispute well resolved to not having a dispute at all. So we should be providing tools to help people avoid disputes in the first place. Now, when I'm talking about this as part of the court system, as just mentioned, I call this the extended court, but it can also be offered as a private sector offering or by charities or by educational bodies. And I call them front end. It's a form of online dispute resolution that sits in front of the court system. Two differences from ADR. One, again, to stress again, I think these services should provide online substantive legal guidance and help. And secondly, huge challenge here, wouldn't it be wonderful if we could link these front ends somehow to our court system so that, for example, we could pass, when these front ends don't succeed in resolving or dissolving the disputes, we could pass the data directly into the court system more efficiently. And somehow, and here's the big challenge, can we put in place some kind of process whereby the determinations of these front ends are somehow enforceable as court orders? Now, at LawTech UK, with which I'm involved, we're doing a pilot exactly to explore this, a platform for small businesses to enable them rapidly and affordably to settle late payment disputes without costly recourse to the courts. And as I say, what we're really working on is some method of enforcement so that if this form of electronic ADR doesn't work, then quite quickly the determination of that front end can actually be some kind of enforceable court order. Finally, in the last minute, what role might AI play? I wrote my PhD in Oxford in AI and law in the 80s, and I say with some confidence that most of the short-term predictions being made about AI overstate its impact in law, but most of the long-term predictions understate its impact. We're living in an era of increasingly capable systems that we don't simply program, but can learn from huge amounts of data. And so my closing thought on this, but I want to say it is many years from now, we have an emerging class of system that can predict the outcome of disputes. Why can't we use a similar kind of system so that a public court service would involve predictions as determinations? So in Brazil, for example, where they've got a backlog of 80 million cases, these cases will never be heard. Well, why couldn't they build a system that would predict the outcome based on past decisions of that court system? And that prediction would be every bit of binding as a formal court determination. I'm not saying this is the answer, but I want to put that forward as a thought experiment. It often dominates Q&A afterwards. This is not an immediate tomorrow application, but I can see towards the end of the 20s, this might be used quite extensively. So finally, our short-term challenge, it seems to me, is to stabilize and improve the ad hoc temporary systems that are currently being used so we can minimize the disruption during the remainder of the crisis. Our medium-term challenge is to industrialize what's gone well during this COVID crisis and make sure that the experience of the COVID crisis is being fed into court reform programs around the world. Long term, I think we need to think far more radically. Is court as service or replace? I think we need to shift our default setting. We need radically to redesign our court system, not just changing the interface so you see one another by video rather than in person, but we need new rules, we need new people, we need a different way, a radically new way of avoiding, containing, resolving disputes, a whole setup that's superior, sustainable, and is accessible in comparison today. So my conclusion is, although many people think we're past the finishing line with video hearings, I believe we're just at the foothills. Back to you, Michael.
Richard, I can't thank you enough. That was quite a tour d'horizon for everything that you've worked on in your career that has been a leading career in this field. And you underlined a few things that I want to just quickly comment on before we turn to some questions for each panelist. One is that you mentioned, that people have said that you were prescient for looking at this, and I've seen in your writings that you've been talking about this issue since the 1990s, and half of me says that in and of itself should be a source of worry for us that it's taking this long for your prescience to finally come to fruition, and it's only happening because of a crisis. But on the other hand, as you say, the long-term predictions have been wrong in certain ways, and the short-term predictions have been wrong in certain ways, but not in the ways we might have expected. A second point you raised that I think Sandy mentioned as well, which I think we all have to keep in mind, is that there are two phases of technological advance when something like this happens, like what we've been through recently in this crisis. The first is to say we have to find a short-term solution, and let's put everything in Zoom, dump everything into Zoom, and then we can do what we did before in Zoom. But then smart people start thinking, well, actually what we did before didn't make that much sense in this way and in that way. And suddenly there are sometimes small, sometimes large changes in the technology and in the thinking and in the productivity of the way we do these things. And some of us have already seen these things outside the question of how we manage justice, really just in our day-to-day work. But the notion of automation upfront, but transformation in the longer term, I think is inescapable for us as lawyers if we want to address the backlogs and the significant gap in the access to justice globally, particularly in developing countries. And then I guess the other point you mentioned that I can't resist commenting on, and I've also seen you comment on this in your work, is that as lawyers, we may not like to hear this, but we tend to be a fairly conservative bunch, at least in the way we do our work. And some of that, I think, comes because we believe that there needs to be a sort of sense of solemnity or augustness in what we do that has to be inspired by and inculcated into those who come before us in courts. By grand buildings and Latin language. But in the end, what we need to be doing is drilling that hole. We need to be finding a way to deliver that service rather than thinking about it in terms of the tool itself. So I think these are all fantastic points, and it actually gives me a good opportunity to segue into some questions for our other panelists who've been very patiently waiting. So Elena, if you don't mind, I'll start with you. Let me first ask you about access to justice in commercial disputes in Ukraine, so we can turn to an example in practice. And in particular, what major challenges have you seen? Do you think that online courts, as described by Richard, are a solution for Ukraine? Have they been in practice?
Okay. Hello to everyone. It's a great honor, a pleasure for me to be here and take part in such interesting discussion. Regarding access to justice in Ukraine, I can say the following. In general, access to justice in commercial disputes is not too expensive in Ukraine. Court fees are comparatively low, and Ukrainian lawyers' routine fees are affordable even for small businesses, if you are not talking about top law firm fees usually. Litigants, but we have a problem that litigants can represent themselves without an attorney, and you can lose a case if you do that. Because procedure is rather intricate, complicated. So as Richard now said to us, it's a way to lose your case if you go to court without a lawyer. And we have another challenge and another big problem. Due to such easy access to justice, our courts are overloaded with the case. And this is one of the main challenge, actually. For example, to understand the situation, our Supreme Court decides about 100,000 cases per year. This is a huge amount, huge case flow. And with such huge case flow, we are not able to ensure uniformity of practice in our courts. And that's why it's hard to make any prediction, as Richard told, because possibility to make our practice predictable, our decision predictable, it's one of the components of the rule of law, and it's very important to develop ODR tools, any ODR tools, and we have a problem with that. It's believed that the adjudication of commercial cases in Ukraine is very slow, but it's not true for commercial courts. Our commercial courts regarding the terms doing very well. We have a high clearance rate, no backlogs, and average it takes about 9 months to adjudicate commercial case if you are talking about all three distances. But the cases of business matter also can be decided by other courts, administrative courts, local courts of common jurisdiction. And that is a problem because these courts have a huge case flow and backlogs. Adjudication cases in this court can take years. And the situation became even worse due to pandemic because court delay and postpone many case hearing. Since the start of pandemic, our courts were not closed. We continued to hear cases as per usual, but physical access to court building was limited. Litigants were strongly recommended to communicate with the court remotely. And I can say that Ukrainian courts were comparatively ready for working in such new conditions and to work in pandemic conditions. And the RFID tools have already been used in all courts of Ukraine. So all our judges and staff has computerized workplaces, and we have a hearing room with the necessary IT equipment. Video conferences has been actively used since 2012, and since the pandemic, participant of processes, our litigants can communicate with the court from their mobile device. Previously, it was impossible. File exchange between litigants and courts by emails also was introduced in 2013, and all our court issues issued in electronic form and filed into Unified State Register. Generally, I can say that in many cases, litigants now have the possibility to not attend a court at all. But the most important information, most important fact in context of what Richard said right now, that is in 2017, a simplified procedure was introduced for small claim cases and non-complicated cases of all types, civil, commercial, and administrative. Adjudication of such cases can be often carried out in shortened procedure without an open court hearing at all. We call it written procedure. Unfortunately, we have no statistics regarding this sort of cases. But I would like to tell that actually, due to this new procedure, and it was a revolutionary one for Ukrainian justice system, we have a real online courts without court hearing in many types of cases, in category of cases. But I see another problem. Richard told us about online judging. In Ukraine, we have a problem with that because our judge cannot work remotely. So if judge is ill or cannot or have to isolate for some time. He cannot work in from home or from another place. We have no access to our electronic case management system. And the problem on top of this, we still work with the cases in paper form. So, for example, if a case had been filed electronically, our court clerk prints it and put it in the paper docket. And that is a problem. And I think that to develop a real online court, we should also put our attention to the possibility to judge, to work online without presence in the court building. It's important, especially now when when we have a pandemic. So that's my brief comment. Thank you.
Excellent. Thank you very, very much, Elena. And actually, you raised another point, which I think we haven't treated yet, but I'm sure will come up, particularly in the Q&A. You said there are no statistics on how this has actually worked out since the reforms in 2012 and 2013. And there's another thorny, but potentially technologically transformational question, which is data. In every other area where we're digitalizing things, we ask ourselves, what are the opportunities for data? And isn't that where the real opportunities exist for productivity increases and et cetera? But of course, when you're dealing with courts and online access to justice, data is a much more complicated question, particularly within the context of data management and privacy regulations. So there's another subject which I'm sure will come up, but let me move, since we're already well in and still haven't heard one word yet from Klaus, over to you, Klaus, because one thing, this being Law, Justice and Development Week, one thing which I think is on everybody's mind is that when we talk about remote courts and online courts, we're thinking, I think a lot of us have a developed world image in our heads. But in fact, we're here mainly as practitioners in development. What I'm wondering is the challenges that both Richard and Elena have mentioned with regards to access to justice. Do they differ between more developed jurisdictions and emerging markets?
Yeah, thanks, Mike, for the question. Yeah, in our experience, the difference is quite stark, of course. Even without going into the court system, and you look at the difference between us sitting, here on panels, our living conditions, our access to technology, our ability to telework, our ability to, keep our kids in school, even when the schools are closed and only operate virtually. This is a very stark difference from the reality of people in low-income countries, especially poor and vulnerable groups. So the same is true for the justice aspects, of course. One important aspect is the ICT readiness in a given country. We talk about all the things that we can do in high and maybe middle-income countries, but there are low-income countries that may not have even reached a level in ICT readiness from where they can increase their level of e-services. Others may be in better shape, maybe somewhere in between, and it may require, some upscaling. But many systems don't have that opportunity. It's also that overall, I will generalize, of course. Overall, the justice systems in developing countries, in low-income countries in particular, are more dysfunctional than in high-income countries. There is a correlation between the income level and the level of rule of law in a country. So part of that is then reflected in the infrastructure that is available to deliver services. And here we talk about the ICT infrastructure for what we're talking about. But the problem is also related to capture of the systems. Like with many other things that are being done in low-income countries, sometimes you can't help it, and you think, well, this makes life easier for people who are already privileged and already have access. And, so online filing, great, the lawyers will be happy, at least the lawyers, the rich lawyers, who have big law firms, who operate in the capital city, and who are among the most privileged in the first place. So while everybody else is going to be left behind. So this is a huge challenge, of course. It doesn't mean that you shouldn't explore the potential of e-justice and digitization, and especially digital transformation. Sorry for throwing all these buzzwords out, but I just want to make the case for, not refraining from doing it. Yes, explore the potential, but take the justice needs that people have, that specific real people have in real life situations, and try to tailor the services to them in a way that they actually get them solved. Whether, for some this is e-justice, and for others that's something else. I think this is the main objective. And doing this kind of reforms, digitization or digital transformation in developing countries is challenging, because in many countries, the ruling elite benefits from the system as it is. Lawyers benefit from the system as it is, including from the dysfunctions. Petty corruption in the system exists because people, make a living on that. And so if you come and, you want to transform this system through digitization, you will run into huge resistance. And so this is a challenge that we are already facing pre-COVID. And of course, now that we are going to move more into the digital transformation field, it will stay with us. And it's going to be very interesting for us to find ways to deal with this.
You make a great point. And I think when Professor Suskind had his earlier remarks, he mentioned this notion of industrialization of good solutions once we've found them. But at the same time, one wonders if in the sort of mass availability of good solutions for access to justice online, if we need to have multi-tiered solutions, ones that can be scalable and can be deployed differentially depending on capacity. From country to country. And I guess that leads me to you, Richard, with a version of that point, or a twist on that point, which is that I wonder, the case studies you've done recently have been focused on the UK, which obviously has perhaps the most sophisticated legal system, and certainly one that people think of that way. I'm wondering if you've had a lot of time to devote to thinking about how the types of innovations you've proposed could be deployed easily and well in the developing world.
Well, thanks very much. Yes, my own practical work tends to be in the UK, but in my book I write about other jurisdictions, and certainly over the COVID period I've been in discussion with numerous developing economies. It all strikes me when people come to the UK to learn what we're doing, they often say, well, Richard, we're wanting to copy what you've got in place here. And I look at the large pillared buildings and the gowns and all the rest of it, and frankly, the delays and the cost and the domination by lawyers. And I think, I'm really not sure this is what you should be copying. And so the great opportunity, I believe, in the developing world is to leapfrog our traditional system. And all I can say is, if you have a look at the setup and say the Civil Resolution Tribunal in Canada, which is okay for a fairly low value, a very restricted area of low value disputes, but that shows you how at very modest cost, one can set up a very effective public dispute resolution system that is absolutely user-centric and is focused on the needs of particular, often people who would otherwise be alienated from the system, people who are vulnerable. The reading age, for example, that's expected of users of that system is 10. The system is designed with, it's not designed by lawyers for lawyers, which is our current system. It's designed by non-lawyers for non-lawyers. And of course, it recognizes the bindingness and the authority and the solemnity of the law, but it provides an entirely different user experience. And the procedures are far simpler, and they're often embedded in the system. And so it seems to me, first of all, that there's this opportunity to leapfrog. Secondly, that the development of these online services and systems, I think, is far less than the development of large traditional court buildings and infrastructure and the drafting of huge bodies of regulations and rules and so forth. It's an entirely different approach. The third thing, and this is something very much in my mind, is that what I believe we need, and I'm hoping to do some work in this area, is some kind of standard global platform, a very tailorable set of tools that would allow people simply to set up a version of this for their own jurisdiction. They could populate it with their own rules and procedures and data and tools. But I think every jurisdiction could benefit from having that kind of kickstart, that kind of shortcut. Because what I'm very keen on is that we gather together our common experience of remote and online courts, that we don't reinvent the wheel, that we don't duplicate the effort, and that we can allow developing jurisdictions very rapidly to climb the learning curve based on the experience of others.
In fact, and that's a great point, and it's something that keys into other work done in development throughout places like the World Bank, where leapfrogging is a solution that offers the opportunity to do something much better and much smarter in developing countries and avoid some of the shall we say, legacy costs of the system. And you don't need to build big august buildings to be able to sort of have an M-Pesa style solution to the courts in countries that still need access. So unfortunately, we're reaching the time when I may need to move on. So if you don't mind me putting a bit of a break in the middle here, I just want to thank everyone very much for this very interesting take on how to adapt online courts to emerging markets and pointing out the major challenges. Again, with apologies, I have to leave you in the hands of my EBRD colleague from our legal department, Veronica Bratazzano. But the seminar will go on, so please don't drop off. Before I go, let me just put in a quick plug for the European Bank for Reconstruction and Development's legal transition program, which has been working on institutional reform measures to strengthen contract enforcement for over 20 years. As part of our work at EBRD towards digital transformation in the countries where we work, LTP is working to synchronize efforts in legal reform with the broader innovation-driven agenda of the bank. We also hope that discussions like the excellent one we've had today and we're continuing to have today will inspire initiatives to consider implementation of online courts. And EBRD, as well as other MDBs, should stand by ready to help with that. So with that, I'm going to hand over to Veronica, if you're there, Veronica. And there you are. Excellent. Thank you very much, and I apologize again.
Thank you very much, Mike, and hello, everyone. Thank you very much again to our panelists and to Mike for such a brilliant engagement with all the speakers. Let's continue our discussion. But before we do that, let me remind our audience to submit their questions into the Q&A box on the right-hand side on your screen where you're watching us. We already have quite a few questions, so it already sparked some good thoughts and discussion. And also there is a poll with 2 questions on the right-hand side of your screen. And please do answer these questions as you go along. We will discuss them towards the end of our event, and we'll perhaps discuss more about challenges to establishing online courts. We will also have a Q&A dedicated part of our event towards the end of our discussion. So let's dive in back and continue this interesting discussion with our esteemed panelists. I think maybe let's consider in more depth this idea about transformation and how online courts may contribute not to automation, to use Richard's definition, but also to actually transform the way we do justice, including in commercial disputes. So I was, although Olena did mention a few points about online courts not necessarily requiring a hearing, I was wondering if you could develop that, Olena, and what is the place in Ukraine for online courts which do not require hearings? And maybe you could also comment on the other aspects of online courts which might be most useful in Ukraine. And what do you think about it? I think you have muted yourself.
Oh, okay. Sorry if I was delayed.
No worries.
Went wrong. I don't know why. Thank you very much for this interesting question, Veronica, because actually it's a revolution approach in Ukrainian courts to have to adjudicate a case without a court hearing. Because even students in Ukraine know that open court hearing is one of the main components of the rule of law, and it's axiom. So at first glance, adjudication of case without a court hearing looks a little bit unfair, especially from litigants' point of view. However, I try to look at the situation, and if we look at practice in Ukraine, as I told before, case flow is enormous. This results in a very short time frames to case resolution required by law. For instance, we have only 2 months to decide a case, a commercial case at the Supreme Court. Each of our judges, as a member of court bench, reviews up to 2,000 cases in a year. As a result of this, the average time allocated to case hearing, even in the Supreme Court, is only about 30 minutes. And please note that according to our procedural code, we have the outdated and all requirements to decide the case immediately after the hearing. Thus, only in 30 minutes, our court should hear the litigants, ask questions, have deliberation, write a short decision without motives, and announce this decision. Announcing meaning that we should read all the text of decision, not just explain it to the party. You can see that that's really unrealistic, and it often turns our hearing procedure into a mere formality. So when I came to work to court, I'm interested in what we can do with this situation, because I had the feeling that we waste of time, that we waste our time to make such very formal hearing. I ask litigants why they're interested in such hearing. I got the following answer. First party often believe that if there is a panel of judge, there is a risk of wrong presentation of cases by a judge reporter. So our litigants afraid that the judge overloaded with all these cases has no enough time to look at the case material, to draft motivated court decision. Another reason why litigants may want court hearing, they want more public and media attention. They think that it may help to win the case and offer more transparency. From the judge perspective, hearing takes a lot of time and resources, and they are often postponed. This contributes to the delay and implies more work to the judge, who has to review case materials again and again, because we postpone the hearing after several months usually. So less hearing, more time for judges to study the case, to draft a good reasoned decision. With regard of transparency, I think that in the 21st century, the concept of being public has been changed. I remember that Richard told about that in our last webinar. To be public means to be on the internet now. Publicity of decision and traceability of all the steps may actually offer more transparency than a mere hearing. All in all, I believe that it's time to remove the need for hearing wherever it's possible. And I would like to tell just little examples of that. For instance, in our Supreme Court, the most civil and administrative cases are adjudicated in the written procedure by default without an open court hearing, and it works very well. For commercial cases, the law requires a court hearing as a general rule with small exceptions. I think it has to be changed because the Supreme Court decides a matter of law, not a matter of facts, and we cannot accept or evaluate new evidence. That's why the participation of parties is not so important in the Supreme Court. So it's my recommendation to remove hearing wherever is possible. Thanks.
Thank you, Olena. Yes, indeed, excellent point. I don't think many participants many litigants are happy with a hearing within 30 minutes and a decision taken and everything all in one. I guess their hope would be for a more considered deliberation. So perhaps online and paper submissions, as in written submissions, might give a better opportunity for a considered deliberation of a judgment, and also contribute to the efficiency and thus make the courts and the case flow not so huge. And what do you think, Klaus, about this distinction between remote and online courts, and whether the pandemic and the effects of the pandemic as in online courts becoming more and more obvious and used, whether there are any blurred lines between these two concepts that have emerged as a result of the pandemic?
Yeah, the impact of the pandemic on remote courts, what Richard called, it's basically like doing the same through technology, whereas online courts are the ones that would be like digitally transformed. For international financial institutions like ours, it is very challenging to get this difference across. I think we're not alone facing the problem that many judges, justice stakeholders in client countries and elsewhere, to be fair, when they think about digitization, automation, digital transformation, e-justice, you name them all, there is often a lack of vision. There's a lack of vision, and there's this naive belief that if you just bring in computers and train people a bit like to use them, basically screens, printers, scanners, all of this will solve dysfunctions in the system. So even pre-COVID, it is rare for us to have a champion of change who has the vision of really using automation as an opportunity for business process reengineering and as a potential for digital transformation. I think now the challenge that we are going to face is that we ourselves are still in the process of figuring out what this new online world, these digitally transformed jurisdictions will look like. We have examples, of course. In the meantime, we have people who've been thinking about it for a long time, like Richard. But I think we are still in the process of figuring that out. And so instilling this kind of vision is extremely difficult because it has to be driven by people locally. It's no way that we can, bring knowledge somehow, packed up in a package and then, deliver the package is unwrapped and, oh, now we have the knowledge. And that's really not how development works, of course. So that is a challenge, and the challenge has been exacerbated by COVID, and the willingness to engage by the elites that we often engage with the willingness of them to engage, is sometimes reaches limits when it comes to inclusion, when it comes to reaching people who really don't have access to justice, and then to make the case that it should be user-centric, users being everybody, not just the privileged, is really tough.
Thank you, Klaus. Yes, indeed, we definitely, in the developing institutions, have to consider tailored approach and identify precisely the needs of the market and try to tailor the solution to what is necessary on the ground. And tying to this, Richard, what do you think about the challenges that Olena mentioned that are currently in Ukrainian justice sector, and how online courts could respond to those specific challenges, as well as if you could perhaps comment on this blurred lines between online courts and remote courts that became more prominent after the pandemic. And when I say about the specific challenges that are in Ukraine, I mean the flow of cases, the fact that there is such a limited amount of time that is allocated to parties to each case, and also the fact that litigants don't have enough skills to participate in the process in person.
Well, thank you, and thank you everyone for their contributions and observations. I think in relation to litigants not having enough skills, that's precisely why I recommend, and have dealt with this at length in my book, recommend the introduction of extended courts. We need to provide simple diagnostic tools to help people understand and enforce their entitlements, to help them understand the remedies available to them, to help them structure and organize their arguments, and to help them organize their evidence. I believe this can be done, but it's a whole new chunk of provision. If the answer of many lawyers, of course, and I understand this, is that you need a lawyer to help you do this. But that's why we have an access to justice problem, because most people can't afford lawyers. So if we assume that lawyers are by and large unaffordable, that public legal aid is reducing as it is across the world, we have to think of more imaginative solutions. And again, I commend you to the Canadian system, where if you have a reading age of 10, you should be able to work through these issues for yourself. Now, I know a lot of people think that's unworkable, but I believe, and we're here to talk about commercial disputes, people who are running small businesses, who are dealing with contracting every day and so forth, will be sufficiently able to read and understand and follow the advice and guidance that's offered. And if you structure it in the way like flowcharts and decision trees, and you have pre-populated standard arguments, and if you explain to people how to organize and present their evidence, I believe over time we'll develop tools that can indeed help people to represent themselves. Now, in England, the interesting thing is that we have lots of people representing themselves. They're just doing it by and large quite badly, because they don't have the experience, they don't have the knowledge, they don't have the tools. And our civil procedure rules extend to over 2,000 pages. How on earth can they master them? So we need to rethink how it is that we present to the court. So I think in so many other areas of life, we quite naturally turn online to educate ourselves, to understand phenomena beyond our normal range of experience. Why shouldn't we do this in law? I also think if we greatly simplify our procedures, that would help immensely. So it's not to try and help people understand the 2,000 pages of rules. What we're seeing in England and Wales is we need a very simplified set of procedures. So that's one point. The second point, I think the answer, in fact, has been made in a variety of ways by both of you, that if you're having synchronous hearings, either by video or in physical courtrooms, and there's limited time, It seems to me if there's a large caseload, that problem is insurmountable. So you need to adopt an asynchronous solution, which allows people offline to spend time understanding their problem and crafting their own submissions. And on an asynchronous basis, that time, it might be hours that a small business owner will spend in organizing their evidence and providing their arguments. But that will be in his or her own time. From the judge's point of view, they'll receive the arguments and evidence and be able to dispose of it quite quickly. So I think the answer to the reality that most physical court systems have very little time to hear each participant is to move to asynchronous hearings so that they receive, and you can constrain it in terms of length and so forth, so that they receive a distilled and far better considered representation of facts and law than is possible for a self-represented litigant in a very short hearing. Now, you asked something, another question which I didn't quite understand about the blurring of the distinction between online and remote. Can you, Veronica, if you just clarify the question for me, I'll do my best to have an answer.
Yes, I think in the minds of many people, remote courts and online courts became quite a blurred notion due to the fact that during the pandemic, a lot of the proceedings were moved online. And in a way, it's even harder now to explain this distinction between what you mean in your book as online court and what a lot of people perceive them to be as online court.
Yeah, I'm sure my book's confusing to that extent, but it's interesting that I called it online courts because I do talk about video hearings quite a lot, but I don't, as I said to you earlier, I don't think dropping traditional hearings into Zoom is that big a deal. I know everyone's very excited by it, but frankly, people have been doing this in Australia since the 80s. The reality is, the reason people are excited is because they were so dismissive in the past that this would never be possible, they paid no attention to it. And so that's been funny and exciting that suddenly lawyers and judges are waking up to something that a number of us have been saying for I don't know how long. But the real transformation for me is into what I call online courts. But let's just take a step backwards, because I put together this terminology certainly for the English judges because I realize it's confusing. The reason I call it remote courts is anything that's not a physical court hearing is a remote court. It's undertaken remotely. And then there's three different categories: audio hearing, video hearing, paper hearing. That's it. It's not much. Now, you maybe, if I had the chance to rewrite my book, I probably wouldn't give it the same title. I might call it paper hearings, but forget the title of my book. Now, you might also want to say, well, let's call everything online courts as well. I don't care. But the basic thing is there's three options: audio hearing, video hearing, paper hearing. That's it. Not much more complicated than that. But we just need to agree on our terminology. Lawyers love this stuff, though. They can spend years. I mean, I'm already seeing lawyers who know nothing about this drawing fine distinctions that none of us who are experts in the field will think are of any moment. So we shouldn't dance in pinheads. We should get on trying to increase access to justice.
Excellent. Thank you, Richard. Indeed, we should concentrate on what we are after, not necessarily the terminology. And the transformational element is the one, the most important one for me, at least. And I'm not sure if calling it paper courts would give it the same shine as
Agreed.
online.
I'm not sure that either. But what I'm trying to say is let's have conceptual discussions about audio, video, or written asynchronous submissions. Let's not have big arguments about the terminology because we've got work to do.
Exactly. Okay, I will. We keep receiving questions in our Q&A box, so I will try to weave in to our discussion some of the questions, and also to tie in with what has been said until now. I will turn to Olena and ask about the space in Ukrainian courts for making this transformation and making the proceedings more user-friendly, and also the tools to access courts more user-friendly towards litigants. And to add one of the questions that came in the Q&A section, maybe Olena, you could comment on whether you have noticed since the pandemic that the backlog of cases has increased, and whether the number of cases has increased because of the disruption to contracts in real life.
Thank you for interesting question. Yeah, I already told that Ukraine has an array of tools that we use to make online courts functioning, but and we try to develop new tools. For example, Ukraine continues to work hard on digitization of entire judiciary based on the Estonian model. And currently we have electronic court. It's a pilot online program that can help our litigants to get access to case files, to get notification, to communicate with court, and so on. It's a pilot program. It still doesn't work well, has very buggy, but we have such a program. But I think that our transition to online proceeding can be appreciated primarily by big and medium companies, by law firms, by attorneys, because both our judicial IT products and our court procedure are still too complicated. Unfortunately, people in Ukraine have no good IT skills, despite the fact that about 80% of Ukrainians are internet users, and about 20 million of people has a smartphone. And more importantly, people in Ukraine don't have basic legal knowledge, and the level of legal culture is very low. Currently, parties, including small and medium enterprises, have a right to represent themselves in any case in court, excluding criminal cases. However, in practice, without professional help, such self-representation in court is usually very poor, as Richard said. People cannot understand complicated procedure. They are not able to collect evidence, to draft legal papers correctly. And finally, they lose their cases, especially if the other party is a big corporation or a state agency with all the resources and good lawyers. Such justice becomes a phantom, an illusion. Therefore, I completely agree with Richard's idea that if you want to make online courts available to the population, to the small businesses, we must take a different approach and make it possible for them, as they did in China, in Canada, in Singapore. Make legal processing easy, convenient, simple, understandable. We should focus on litigants and make court service more accessible to wider public. My experience is only with the system of China, since I traveled last year to see the system at work. There you can file a claim using application WeChat on your mobile phone. Robots using big data and artificial intelligence will answer all your questions and help to collect evidence. All you need that answer to some questions and take a photo of your papers. And in China, they have an online center for enforcement of court decisions. We track debtors by checking their banking account, in social network, when they buy tickets, or book hotels, and so on. And we are talking about new mode of litigation. I do like this Chinese idea that litigation services should be transferred from fixed place and a fixed time to random access and instant services, so as to implement the one-stop online litigation services concept. I am all for transforming our judicial process itself instead of just digitizing the existing processes. I'm deeply convinced that if we want to have a successful online court accessible to small businesses, to public, we don't only need to implement innovative IT decisions but to revise and significantly improve our procedural rules, simplify them. It's also important to note that there is a political will to change public services, including courts. Our president came to power with the slogan, "A state in a smartphone." It means that in the nearest future, Ukrainians can solve any of their lives and business situation online in one click and preferably from a smartphone. And our president promised that a citizen will forget how the official look like and where they are. So this kind of support is particularly helpful for the legislative reform, and it is required for improving our court proceedings.
Thank you, Elena. And on the increase of cases in courts, could you comment on that?
I checked statistics before our webinar, and I see that we have such increasing about 20-30% of cases, and especially in commercial cases, bankruptcy cases. So I think it's not only postponing of the cases, but also impact of crisis, economic crisis in our economy, and impact of pandemic, and it's very negative now.
And I can add actually to this, we at EBRD did a brief research in a number of our countries, about 20 jurisdictions in which we operate, and we asked law firms whether they anticipate, because we've done this sometime in April, whether they anticipate an increase in cases, and 90% of the respondents confirmed that they definitely will expect that there's going to be a huge increase in cases being submitted to courts. So maybe let's briefly discuss a bit about category of cases which are most amenable to this transformation, and to be maybe to be piloted for online courts. Maybe Richard, I'll turn to you with this for a quick view on this matter.
Sorry, I'm not quite fully understanding the point you're asking here.
So I'm asking, what are the categories of cases that are most suitable for online courts, maybe to start with, because in many countries they don't see the capacity
yes,
to...
okay, sorry. I thought you were asking, and what I don't want people to run away thinking that all this technology is being used very widely and best practice is already established. It's very early days for all of this. If we're looking beyond video hearings, if you're talking about video hearings, and that's a question for you, we're talking about video hearings, or are we talking about the asynchronous hearings? Which are we talking about?
We're talking about disputes in, for example, in maybe administrative disputes, or small claims disputes, or tax disputes, which you think that might be most suitable for piloting online courts on.
Okay, sorry, Veronica. I know I'm laboring the point, but it goes back to our distinction. Are you asking me when can we use video hearings, or are you asking me when can we use the other set of techniques that I'm advocating?
Oh, I see. Okay, yes. Yeah. The other set, so without video hearings, the paper courts.
So my answer there is going to disappoint you, in the sense that the big bit of work that hasn't yet been done is identifying where these techniques work well and where they wouldn't. Our early work in this, and when I wrote about it in our report 2014-2015, we took the view that it should be for low value disputes, and a gentleman who's now a Supreme Court judge followed up with a detailed report, again saying all disputes over below £10,000. But we now see that, and we've known I suppose we've known this forever, that just because a dispute is of low value, that doesn't mean it's not complex. That doesn't mean it might not involve difficult questions of credibility of witnesses and so forth. And so what we found is that some very, very high value disputes can be resolved by this method, and have been by international arbitration, almost as written submissions for years, whereas some very small value cases, you think, actually, we've just got to get together in person. So my first observation is, I think it's good to imagine this is generally for low-value disputes where less is at stake, but don't assume that all low-value disputes can be handled in this way, because some will still need the traditional hearing. And I also do think there should always be the option for someone to argue online that this is the kind of case because of what's at stake, or because of the nature of the dispute, whatever, a whole bundle of reasons might be advanced, but you can ask for a traditional hearing. So I'd be nervous about, so the default starting point is, when you think of disruption in any system, don't start with most ambitions, start with low value. So let's start with low value. Start with it. The ideal is issues that are where there's high volumes, they're quite routine and repetitive, they're quite process-based, there's relatively little scope for discretion, there's relatively little need to, as it were, look the witnesses in the eyes, because people still believe that can be done. Some people still believe that needs to be done by physically assembling. I don't think it's very, for just now, I'm nervous of these being used for example, for serious crime. But I do think that a good starting point, and this is for the purpose of the seminar, is the wide range of fairly low value, everyday commercial disagreements that arise between small and medium-sized businesses. So that's one category. A second category, I think, when there's a great inequality of arms, it troubles me when small businesses are dealing with very large businesses, that the very large businesses are well equipped with teams of lawyers, the very small businesses don't and can't afford. And so I like the idea of the online proceeding as a way of leveling the playing field. You mentioned, I don't want at this stage, because we just haven't got the learning, I don't want to say that tax is suitable, whereas property disputes aren't. We're not at that stage. I think we're still feeling our way. I know that's not a terribly helpful concept, but I want to underline the point that we are at the foothills. There's maybe 20, 25 good examples of this around the world, as opposed to video hearings where there are literally millions of illustrations. So it's early days, and I would like to start low-value disputes between small businesses and between small businesses and large businesses where there's a clear disparity of capability. I also do think, this is maybe beyond the scope of this, that for a lot of tribunal hearings and disputes between citizens and the state, I believe this is also a very suitable mechanism, because again, there's this disparity of capability.
Thank you, Richard. I think it is useful to, in a way, your advice of not being too ambitious and trying to start small and then build on it. So that's a key takeaway for me. And leveling the field for parties is an excellent point as well for us to bear in mind when we are looking at developing such courts.
Can I make just one practical, commercial, pragmatic point, that one can have all the policy and philosophical thinking, but in the end, you're often just looking for the bottlenecks in the justice system. You're often just looking, saying, there's a disproportionately large number. So if you look at, for example, in Brazil, when they've got the 80 million disputes, actually a huge number of them are tax disputes. So it's worthwhile isolating the bottlenecks, isolating where there's very high volumes, relatively low value, and just taking a pragmatic view. We need a new process there. We need a new procedure there, because it's dragging the whole system down. So you can either start philosophically with what is the nature of judicial decision making in different kinds of cases and build a view there, or you can just say, where actually do we really need to cut through the delay?
Exactly. And the countries have a chance to have a stamp on deciding what is best, and not looking for a perfect solution outside, but rather look inward and decide what is best for them. We are approaching the end of our discussion, so and I did want to maybe read out to all of you the results of the survey that we have put online. So the first question which we asked our audience was, do you think that online courts may be a solution in your jurisdiction? And the answer is fairly obvious. So we definitely, the audience is definitely convinced that it is going to be useful. So 71% replied that it's going to be a good solution. At the same time, there is a camp of unsure. That's the second 19% thought that they're not really sure that whether it's going to be a solution, and then 11% said no. So there is still work to do there. And then we wanted also to see what is the perception, and just to give you a perspective of the respondents. So we have 133 people answering the first question. And then the second question was about the challenges of establishing online courts, and what does the audience think about what are the biggest challenges. We gave them some options on what we thought that we think might be the problem. And frankly, I was always thinking that budget is going to be one of the major impediments, but actually our audience thinks that it is the illiteracy of population and of the judiciary, which might be one of the biggest challenges for establishing online courts in emerging jurisdictions. And the second biggest challenge was opposition from judges and the legal profession. And the budget is in the third place with 17%. And this question, we also had another option, which was unfairness of the online proceedings, but only 6% thought that this is a valid problem. So we had, and 144 people answered this question. So I think it's interesting just to understand where people, what do people think about this. And we only have 5 minutes left. And we have some questions in the Q&A, and I saw Richard, you raising your hand, so I will give you a chance to answer. But maybe first, I will also pick a question from our Q&A session and pin it on you as well. Let me see. One of the questions was about data security and data privacy, and how online courts and moving towards online courts will embed this and reflect this in their operations, and how big a problem you see this to be.
I'll answer that in 2 seconds there. I just want to make the observation, obviously the people who take the time to come to this event are probably on the face of it interested. In many ways, the people we need to persuade are the people who haven't come to this event. And so it's a rather self-selecting audience. I do think, though, and it relates to a question you asked me, that what will begin to change is once we have more case studies and evidence. For most lawyers and judges who are cynical, evidence is a lot more powerful than arguments. So any amount of books that I write and so forth is not nearly as good in some ways as seeing, here are 20 of these systems up and running, speaking to judges and lawyers who say, actually, it's really good. Because that's what we've seen in the COVID period with online hearings. We've seen people experiencing it as good and hearing good case studies of it. So the spirit has to be, I think, of pilot, experiment, evidence, case study, much like we're seeing in the sciences. We can't just jump to some big vision of a big change. People won't come in that way. We need to do it in a more incremental way. As regards confidentiality, as regards data security and privacy and so forth, these are clearly huge issues. I don't think they're showstoppers. I don't think any of the dangers or risks that they pose are such that we shouldn't proceed, but it means we should proceed with these issues in mind. And remembering also, as regards confidentiality, the flip side of this is people worry, are these systems transparent enough? Are we seeing open justice? So one of my hopes is that these new forms of remote hearings actually are more open and getting the balance between genuine openness so that anyone in the world can look at some kind of proceeding on the one hand and respecting people's privacy in the other is quite a difficult issue. But there are experts on this who are devoting their time to it. As I say, this should not be a reason for not proceeding. It should be a reason for proceeding with caution.
Thank you. And we are fastly approaching to the end of our session, but I do want to also ask Olena to give us a bit of a perspective on these challenges and potential opposition to establishing online courts, for example, in Ukraine, and also the challenge of IT illiteracy and judiciary. So what do you think in this regard in Ukraine? Is this a big problem? What are your thoughts? Does it not work to unmute yourself? Maybe the organizers?
Oh, okay.
Here you go.
I have to screen and my mouse. Just looking for. Sorry. I would like to give a brief comment. Actually, we have about 5,000 judges and 25,000 court staff, our clerk, and just a few of them have a high level of IT literacy. Most of our judges and clerks possess basic skills of average computer users, and we have a few who cannot use computer at all. So, of course, a small number of judges is ready for full-fledged digitalization. Certainly, it will be opposition, it will be sabotage, and a lot of complaints. But I am completely sure that in a couple of years, the majority will wonder how it was possible to work in another way. I believe in inline court. I believe in digitization. It could help us to make our most achievements in the judicial sphere. So I believe in inline court.
Thank you, Olena. And yes, it's very encouraging. And indeed, as you and Richard mentioned, it's trial and error and identifying the best way forward. And I remember at some point you mentioned this Charles Darwin's quote about transform or die, or what was it? I guess it's for our courts as well, quite relevant. I not to skirt over completely the question of budget. I understand that Klaus, from his experience in working in developing jurisdictions, has some thoughts on this.
Yeah, just very quickly. I mean, there's one thing that we haven't mentioned, which is we are aware that courts face an increasing caseload due to the impact of the social and economic crisis that is being caused by COVID. But at the same time, the budgets that will be available for countries, to spend will decrease because of the same impact of this crisis. Less tax revenue. So the justice system, and all the investments that we are talking about will compete with investments that will be needed in other sectors, including, on social aspects to mitigate the impact of the crisis. So moving forward, I think, especially for the international financial institutions, there is a meaningful role to be played. But at the same time, the international community may also be struggling with providing the resources that are needed. So it's good to have that vision. It's very important. And when it comes to the implementation, we have to be very focused to make it happen in a way that it's actually affordable and will see the light of day.
Thank you, Klaus. Yes, of course, we shouldn't forget that the budget necessary for building and maintaining digital tools is definitely one that is quite huge and requires some thought. At the same time, we've been told quite often that it's quite the costs and the savings from using digital tools are quite significant as well. So this is another consideration which feeds into the question of budget. Unfortunately, we are coming to an end, to the end of our discussion, and we could, as we could see, there are so many issues and topics that are connected to this theme, so that we could discuss forever, but we have a limited time, and I'm very grateful to our speakers for this very lively and interesting discussion, and for all their insights, and also to our audience for being patient with us and for submitting all their questions. There were a few questions about how international development institutions will be helping with establishing online courts, and whether there are going to be any projects in these directions. This is perhaps this type of discussions do contribute to focusing our mind on these initiatives, and we are definitely looking into this, into potential of these initiatives to answer that. Thank you so much. It's been a pleasure, and goodbye to everyone until next time. Bye.